Welcome everybody to the Veterans Joint Endorsement for Judicial Candidates. This is going to be Veterans in Politics International, Nevada Veterans Association, and Armed Chambers Forces. We'll be doing a joint interview of these candidates. Would everybody like to stand for the pledge, please? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. We would like to extend our sincerest appreciations to additional sponsors of the community partners who have supported these professionals' fair and transparent endorsements. Judge Mary Perry and Judge Jacob Reynolds for Department 29. Mary Perry is Family Division P. So we're honored to have you here with us today, and the way this format's going to work is you will be asked a question by each panel member. After they will introduce themselves, you will get to introduce yourselves as well. We will go in order on the questions. You have 1 minute and 30 seconds to answer your question. This is not a debate. This is not you answering back and forth towards each other. This is you answering the questions and not ducking them. So we will start with the candidate, the panel introducing themselves first, please.
Sue Christensen. Okay, are you ready? How do you approach bail decisions? Hold on.
Organization.
Sorry, Sue, one more time.
Nevada Veterans Association. My question is, how do you approach? Okay.
Yadasha Jones, Veterans in Politics.
Gary Jacobs, Armed Forces Chamber.
JP Edwards, Armed Forces Chamber.
Frank Franz, Veterans in Politics and Court Observer.
I'm sorry, Danielle Tarmu, running for Department 28.
Hi, I'm Judge Noreen Demonte. I am your judge in Las Vegas Justice Court, Department 10, and I'm running for District Court, Department 28.
Can you guys tell us the office you're running for and why you're seeking that position?
Of course. So I'm seeking Clark County District Court, Department 28. I've been practicing civil litigation for about 17 years now, representing plaintiffs and individuals and fighting for their rights. I've represented a lot of veterans. It's been my greatest honor to represent veterans. I am seeking this position because I think there's a serious deficiency of knowledge and experience of civil law and litigation, specifically civil trials on the bench. And I'm that person. I have that experience. I want to bring it to the bench and start changing things a little bit. Thank you.
All right, so again, I'm Judge Noreen Demonte, District Court 28 again. It is a civil criminal split department. So my background is as follows. I started my career as a criminal defense attorney first and then joined the district attorney's office as a law clerk. Even though I was an attorney, I started at the bottom as a law clerk. Proved myself, became a deputy district attorney, then a chief deputy district attorney. And I started under David Rogers' administration. So we did a lot of trials. I think I finished with more than 100 jury trials. I was elected to Las Vegas Justice Court in 2022. And this is after a career in the district attorney's office that saw not only that trial experience, but I practiced in front of every single justice court here in Clark County. Laughlin, Mesquite, Moapa, Henderson, North Las Vegas, Bunkerville, Moapa Valley, and Good Springs, which is the Jean area. Additionally, I had experience in seeing those trials through to arguments in front of the Nevada Supreme Court. And the being elected in 2022, I have a criminal stack, and I've been on the bench for 3 years.
Sue, would you like to start us off, please?
How do you approach bail decisions?
So I handle bail every morning. A lot of the bail decisions are actually now handled by our initial appearance court. I wish we would change that because it's a case assigned to me. I should be handling my own bail. But there are some that haven't been addressed down there. Say they come in on a warrant or things of that nature. And so what I do is I hear from the counsel on both sides. I review their pretrial risk assessment, which is a form that we get that lays out their prior criminal history, as well as how many failures to appear they've had, whether or not they have verified address, employment, things of that nature. I also look at their financial affidavits, and I assess whether or not they're going to be a risk to the community. And so our standard is set out by our Nevada Supreme Court in Valdez-Jimenez, where monetary bail is only appropriate where the state has shown by clear and convincing evidence that there's no least restrictive means other than monetary bail to ensure safety to the community. And so I look at every case on a case-by-case basis and proceed accordingly.
Thank you.
I do not address bail decisions every morning. However, I have over the course of 17 years sort of found a niche in my civil law to review and analyze law. And I am very much aware of the Valdez-Jimenez decision. And I mean, I can't really add much to Judge Demonte's analysis, to be perfectly honest, but the most important thing is to listen to everything. Listen to the flight risk, listen to what may have been going on in the person's life that may have affected them in that moment that maybe doesn't always affect them in other moments. And then the Valdez-Jimenez decision really gives a lot of leeway to err on the side of bail, or excuse me, not bail, but letting someone out on their own recognizance. And so I apply the law.
Thank you. Oh, Yadasha Jones, Veterans of Politics. So, Judge Demonte, specifically, you recently handled the case where there were 3 teens that kidnapped someone for the $4 million in currency.
The crypto case.
Yes. And one of the defendants was released with an ankle monitor, and one of them is still incarcerated. And my question is, how can voters be confident that you are consistently using sound judgment that prioritizes community safety over convenience or sympathy when you decide who is released and who is detained pre-trial?
Okay, only one of those defendants came in front of me,
Okay.
to be perfectly frank. It was actually a release decision that changed within 2 days, and I'm not certain the media kept up on that. When the case initially came in front of me, because he was originally released to house arrest, and the police report was not very well defined as far as who did what the culpability was, and it even in communication with the district attorney a couple of days later, when we put it back on calendar, there was more information that the district attorney had. When the bail was originally set, it was a DA that was not all that familiar with the case, and going on Valdez-Jimenez, I couldn't seek monetary bail because they had not proved it up. And he actually didn't qualify for house arrest anyway. And so it was put back on calendar at house arrest discretion. And by then it was a district attorney that came in that actually had more information and was able to flush out the details that were lacking. And then it was set at $500,000 with high-level electronic monitoring should he be able to make that. Because we as judges, we don't get to fill in the gaps. We're limited to what the parties present in front of us, including the state.
Thank you.
Of course.
Gary Jacobs, Armed Forces Chamber, for Judge Danielle. What aspects of your legal career have most directly prepared you to preside over high-volume, high-stake cases in the 8th Judicial District Court?
Well, as a plaintiff's law attorney, we have very high caseloads. And that's actually, I would say, even an issue in my industry, is a lot of attorneys will take on too many cases. But even though I've kind of prided myself on taking a more manageable caseload because I want to make sure to take very good care of my clients, that means that I can work that much harder on those cases. And my experience, so first we work up cases. Our cases go on. They're 2 years before we file, and then 5 years before bringing them to trial. Okay, so these people are friends by the time we're done. And I mean, that's how I treat them, too. I work around the clock for them. So working the case up for discovery and whatnot, we work around deadlines. And we have to meet that deadline no matter what. I've pulled all-nighters. I have 3 kids under the age of 7 that I need to get them to bed. I like spending time with them. And then I work afterwards sometimes till 3, 4, 5 in the morning. And I'm a civil trial lawyer. So when we're in trial, we work 16, 18 hours a day. After we leave the courtroom, we then put in 6 to 8 hours of work afterwards. Thank you.
JP Edwards, Armed Forces Chamber. This would be for both of you. In a media-saturated case, how do you protect juror impartiality while respecting First Amendment considerations?
Should I go first? Okay. Anyone is allowed into the courtroom. These are public proceedings. Anyone can watch. And I know there was a judge recently who got into a lot of trouble, for lack of a better way of putting it, for not allowing that to happen. They are allowed in the courtroom. It is an incredibly high burden to try to keep people out of the courtroom. I've handled not even close to as many trials as Judge Demonte, but civil trials are an entirely different beast. We're in trial for 2, 4, 6, 8 weeks at a time. And the juries, we do ask them questions that are very personal. Everyone's allowed to watch that. It's really on the attorney to ask questions. If you want to get real private with those jurors, you have to take into account that they may not be truthful with you. But really the bottom line is, anyone comes in, those jurors, we just have to account for that. They're maybe not being impartial in their answers. They may be lying to us if we're asking private questions.
So as a prosecutor, I had quite a few media cases. And over the years, and even on the bench, yes, no, cameras are allowed in my courtroom. Media personalities are allowed in my courtroom. I do not prevent people from being in my courtroom, and the First Amendment requires that I respect their ability to report on it, on what they see and hear in the courtroom as they see fit, because the Constitution is above our statutes. In this particular, actually, in all instances. With regard to handling jurors with the media, sometimes they do. They see cameras there, they get a little skittish. You have to just prepare them for the fact that, hey, listen, you're sworn an oath. You have a duty to do this. Now, we do, in the Regional Justice Center, have the ability to take the jurors in and out the back instead of the front. And I had one particular case where I wound up prosecuting someone who was filming members of the jury in the hallway and posting it. And it was a pretty horrific case involving a very violent pimp. And the purpose behind all those people in the hallways was to intimidate those victims when they were coming and going. And then they wound up intimidating the jurors as well. And so it does happen. It's rare that jurors have cause to be intimidated, but that is that, and that is my time.
Frank Friends, Veterans in Politics. So I also do court observation, and I watch these judges. We actually have a sitting Supreme Court justice who 70% of the time when a pedophile case is brought to her, she would give the less than recommended sentence that was even agreed to for pedophiles. How do you feel, and are you going to legislate from the bench when given specific standards for lesser penalties just because of somebody's racial, ethnic, religious, or sexual background?
Absolutely not. Every case that comes before, if I win, of course, every case that comes before me would be decided in and of itself. First, there has to be a certain deference to any sort of agreement towards that the attorneys come from. I'm sorry, I'm very nervous. There has to be deference to those attorneys. They know things about the case that the judge will never know. The judge simply cannot know the intricacies of every bit of the case. And so if the attorneys have come to an agreement, you have to understand maybe there is problems with evidence. Maybe there are issues that you just simply don't know. Give them some deference. Aside from that, you just have to apply the law. I mean, that's the most important thing. Apply the law, listen to the people in front of you, listen to the facts and the arguments, and then apply it. But you can't do the same thing over and over again. You can't look at a person and guess as to how they're going to act in the future or maybe what they did in the past. And just be impartial and apply the law. It's the most important thing.
So to piggyback off of that, yes, the attorneys before you, they know things about the case that you as a judge don't do. I'm going to start with this sentence. I have not ever and will not ever legislate from the bench, full stop. That is not my job. There are people up in Carson City that are in charge of legislation, and that is their purview, not mine. With regard to sentencing recommendations, if the parties agree on a particular sentence, I genuinely follow it unless there is significant concern on my part about the safety this person poses to the community. And I can tell you I have overridden a negotiation between two parties one time. And it was a very severe domestic violence case that originally, down in justice court, I don't sentence on felonies. We send it up to district court where they enter a plea or go to trial, and then they get sentenced there. So originally he had signed a deal to go to prison for 2 to 5 years, and then it got remanded back to me because the deal had changed to misdemeanor informal probation with a treatment program. And I could not for the life of me figure out how that would benefit the victim in the case, or even the defendant himself, to be perfectly frank, because this was somebody that could not do it on the outside. So I wound up sentencing him to as much as I could in Las Vegas Justice Court, and that is the singular time I did that.
Sue Christensen, Nevada Veterans Association. When you're handling a case and a prosecutor does not share evidence with the other side and they purposely hide it, how do you handle that, and what repercussions are the prosecutor's office going to serve? It tends to happen quite often in courts.
So the legal repercussion is that the evidence can be excluded if there's bad faith involved. There is also incidences where if it's happening during a trial, legally the other side is in, let's say if there's a destruction of evidence, negligent destruction of evidence, which it happens, then the jury has an instruction that we give as a judge, that is, you are to determine that this evidence would have been favorable to the accused. So there are legal remedies behind that. Ordinarily, it really does not happen. It's fairly rare, but when it has happened, because I read the papers too, the cost to the community at large and the loss of faith in our system is unfathomable. I mean, the damage that it does. You know, I was a prosecutor for 18 years. Prosecutors have a higher ethical standard, and I always abided by that. I didn't hide anything. I was very open with my communication with the other side because nobody benefits from things like that. Gamesmanship has zero place in our criminal justice system, should not ever be taken into account.
So in civil, is that working? Okay. In civil law, we have mandatory disclosure rules too. And I've handled a number of cases over the years where I've had to work with the prosecutor's department and different criminal attorneys because of sex assault and assault cases primarily. Mandatory disclosure is mandatory. They have to disclose evidence. I have been shocked sometimes at what criminal attorneys have to go through to get evidence. I mean, we don't do that in civil law. You have to. We file motions, we get that evidence, we send subpoenas, we attack that evidence from all sides. And if a judge is not upholding that, and I would never be a judge who would allow that. So as long as the attorneys are informing me of that problem, I'm compelling that evidence to be disclosed.
Oh, there we go. Okay. Yadasha Jones, Veterans in Politics. And this is specifically for you, Ms. Tarmu?
Yes.
Okay. So, and this is about you, Judge
About me?
Demonte.
Oh boy.
Yes. I like talking about people in their face. So Judge Demonte recently had a case where a female recently eliminated her boyfriend, and it was recommended that the bail was put at $500,000, and she put the bail at $750,000, and it was a very severe case. And that bail was necessary because of how severe the case was. And my question is, with how she handled that case, how do we know that you are going to handle the cases as severe as she would, given that in the circumstances how society is now these days, they are very biased towards women?
Judge Demonte is a fantastic justice court judge. Okay, I mean, she has an amazing amount of criminal law experience. So her decision was, I'm sure, based on everything in front of her. I do the same thing. I don't have very much criminal law experience. I have a baseline from externships and that sort of thing, right? So I understand the bare basics. First off, if I'm elected, that department will probably go all civil, because of my experience and because of the need for civil experience on the bench. But number two, I am a very impartial person. That's why I've succeeded in my profession. That's why I have so many people supporting me from all types of areas of law, including people that I've litigated against for nearly 20 years. And what I do is I listen to all of the evidence, and if I don't think that something's recommended is severe enough, then I don't have any problem being more severe. But at the same time, if I think it's too severe, I will pull back too and maybe not recommend that much bail. So the only thing I can really say is that I will apply the law. I don't know the circumstances of this case, and I can't really speak to future cases in front of me. But as a woman, I'm certainly aware of what goes on in society today and how people are treated in courtrooms, and I'll apply the law and listen to all the evidence presented to me.
Gary Jacobs, Armed Forces Chamber. This is a question for both of you guys.
Okay.
How would you respond if a high-profile defendant publicly criticizes your courtroom conduct during trial?
I don't necessarily know about a high-profile defendant, but people tend to come into court and make criticisms all the time. Here's the thing, is I invite anyone to come watch me in court. You can see for yourselves how I handle things. I hear everybody out. There are occasions where I do have to shut down people sometimes. I mean, I don't know how familiar you guys are with the sovereign citizen movement, but in justice court, we get a lot of those. And, you know, as a DA, I would get them. This is where my dislike of social media comes in, because for the first time in my life at age 50, I'm doing social media, and it's only because of the campaign. Because when I first started as a DA, sovereign citizen cases, you would get maybe 2 a year. Maybe 2 a year. And now it seems like it is 2, 3, 4 a week, because it's all just wildfire online about fringe on the flag, meaning I'm an admiralty court, and the Treaty of Friendship, and, you're an ambassador from Morocco, and you're not a driver of the vehicle, you're a traveler. And so what happens is those people come to court and they just go on their rant, and you can't get a question in edgewise, because, I mean, in order to allow them to represent themselves, I have to ask them a series of questions, and they will not answer them. So yes, sometimes I do have to shut them down, and I don't like it, but I can't, I've got 100 other people waiting to be heard.
Frankly, I don't care. People can say there's right to free speech. Go ahead. I don't think a person who's high profile would be representing themselves. So I'm kind of thinking of this as maybe just someone who is upset about a ruling, something like that. Go off, go for it, go. I don't care. That's it's going to happen, right? Everyone loses at some point in the system, and people are going to get upset. And if anything, I'm doing my job, I guess. People should get out there and speak. As long as they're not interrupting my courtroom or the proceedings or trying to influence people in an improper way, that's fine.
JP Edwards, Armed Forces Chamber. This question is for both candidates. A jury returns a verdict that triggers strong public backlash. How do you address post-trial motions alleging jury misconduct without appearing retroactive or reactive to public pressure?
Can you say the first part of that question one more time? I'm sorry.
A jury returns a verdict that triggers a strong public backlash. How do you address post-trial motions alleging jury misconduct without appearing reactive to public pressure?
So, first of all, I swore an oath not to react to public pressure, period. Public pressure is not part of what I do. My rulings are based on the law and the law alone, whether the media likes it or not. Criticism comes with the job. It does. And I'm not there representing myself. When I take the bench, I am just a symbol. I am, one of the Supreme Court justices, and I don't remember which one, but it was a very powerful essay about why judges' robes are black. And it is because it's not about us. It's not about me. It is about the office. It is about the Constitution. It is about the law. So we wear black to fade into the background. And that, it gave me chills, honestly, because, I happen to look terrible in black. I'm Irish. But I wear black because this isn't about me. And the public pressure, I don't care about that. It's about the law.
I mean, I look bomb in black, so. But
yeah.
ditto. I mean, ditto. You have to remain impartial. Jury misconduct is a high burden to prove too. I think that's going to happen with any. I've had some of these cases. I've worked on some of these trials where there's a lot of media attention. People aren't happy with it. I mean, I worked at the law firm who handled the endoscopy cases, and there was a ton of stuff. If you guys remember, it was actually very close to when I started practicing law, nearly 20 years ago, and tons of media, right? And even as attorneys, we get a lot of backlash. And as a judge, you kind of have to raise yourself above that and be impartial. So you just ignore it. It's kind of similar to my last answer. People are allowed to say whatever they want to. That's the freedom of speech. And it's extremely important to exercise that freedom. And it's also extremely important as a judge to rise above it and not let it affect you in any way.
Frank Friends, Veterans in Politics. So on average, before somebody commits their first murder, they've seen a judge or had judicial issues 11 times. This is just on average. It's not every case. But yet constantly you're seeing judges continuously let felons out 26, 27 times so that they can stab people on trains. At what point do these judges need to be held accountable? And after how many cases do you think a judge should be looked at and maybe have some judicial review or removed from the bench for their lack of understanding about the compassion of the safety of the voters and the public? Start with you.
So from a judicial standpoint, we can't legislate from the bench. And so we can't make decisions. I mean, we can't punish judges. What I would say is people need to speak up. People need to speak up a lot. But if I'm sitting on the bench and another judge is doing that, then I unfortunately can't really do anything. Besides, sometimes there are options through the legislative committees, judicial legislative committees. Okay, so those issues can be raised to us. I think that as a judge, if someone came to me with that sort of background, obviously, it has to be considered. One of the questions from the Clark County Prosecutors Association was a question about how much it costs to incarcerate someone per day. And this came up in my interview because I said, it doesn't matter. It doesn't matter. That is not my consideration. Because if that person is doing something where they should be incarcerated for it, if they have a history, if the information presented to me and the arguments before me show that person needs to be incarcerated, they should be incarcerated regardless of the cost. Regardless of how much it costs. I hope I answered that question.
Okay, so not to criticize any judges, but I will say this much. I was a prosecutor for a pretty long time, 18 years. 12 of those 18 years, I was prosecuting repeat offenders. I worked hand in hand with Las Vegas Metropolitan Police Department's repeat offender program. And what we did was we found the people. I mean, the adage is 80-20. 80% of the crimes are being committed by 20% of the criminals. And we would find that 20% and we would target them for enhanced sentencings. No lie. When I ran my campaign in 2022, I had the displeasure of saying that one of the people I prosecuted under that program, the day he got arrested, auto theft went down 20%. He only came to me with 5 felony convictions, but every single one of his guilty plea agreements were plead guilty in this case, and we're going to dismiss 7 other cases. And it came to a head when the repeat offender division detectives, they're plainclothes detectives that stick trackers on people's cars and try to catch them, they had swarmed to try to arrest him, and he was in a lifted, stolen Ford F-150. And the way he fled from these police was so erratic and so terrorizing. He actually monster trucked over one of the vehicles that a detective was in. I heard the radio of these detectives. They thought their partner was dead. I'm amazed he walked out of that. But he's serving 10 to life under the habitual criminal statutes. And we have those statutes for a reason.
Sue Christensen, Nevada Veterans Association. What do victim impact statements in sentencing really, what role do they play and how much weight do they carry?
Having been on the prosecution side and having had victims come before me as a judge, they work. They're impactful. First and foremost, our victims have rights, and they're not just rights in statute. It's Article 1, Section 8A of our Constitution. It was passed by the voters. It's called Marsy's Law. Victims have that right to be heard, and it is ingrained in it's in our Constitution for a reason, because the impact that these crimes have on them needs to be told. It's a story that needs to be told. And I can tell you this much, that it was a very rare occasion when I was a prosecutor that a victim impact statement, I think, didn't be heard by the judge. It was very rare. I think I can count on one hand the number of times I thought a judge discounted that. I encourage victims to talk, and they have stories to tell that attorneys just can't.
I would absolutely consider that. I mean, so as I mentioned before, I've handled a lot of sex assault cases over the years. And in every single one of them, I have encouraged them to write a victim's impact statement. I oftentimes help them write it, revise it, and accompany them to the hearing if it goes forward. A lot of times it's resolved before they're able to speak. It's not necessarily resolved, but they get afraid. So I try to be the support system for them. But it should absolutely be considered as incredibly important. I mean, the person who committed the crime impacted someone, and that someone's life has changed because of that.
Okay, guys, we have a few more minutes, so we're going to do this to test how quick you guys think on your feet. These are going to be rapid. We're going to come right down here, answer them quickly, not lawyerese.
Not lawyerese.
Tarmu. And this is going a little bit back. In Anderson versus Mandalay Bay,
Oh, yeah.
you asked the Supreme Court to impose liability on a casino for a worker's sexual assault of a guest. As a judge, where would you draw the line so businesses are held accountable without turning them into absolute insurers of every employee's conduct?
So the law it's very difficult to prove a business's liability for an intentional tort. That means intentional act, like a crime, essentially. The law is tough. It's really tough. In that particular case, it was a janitor who for some reason had access to, I think it was like 9 different floors of rooms at all hours of the night. So she was asleep in her room around 2 or 3 in the morning. He kind of made up an excuse that there was glass underneath the oh shoot, that's right, I have to be fast. I follow the law. The law has protections for that sort of thing. I mean, it does. And I guess that's all. Okay, that's it. Sorry.
Jacobs for Judge Demonte.
Yes.
Explain the bail considerations under Nevada law and how you balance public safety versus the presumption of innocence.
Okay, so anyone who comes before me until they're, unless and until they're found guilty by a jury or plead guilty, they have that presumption of innocence. However, it's not a however. It's not that I'm saying that I don't see you as innocent. I'm not presuming you as innocent, but you do have to assess the risk to the community. How many times have you been arrested within the past 2 years? How many felony convictions have you had? How many violent arrests have you incurred over this period of time? And how many times am I seeing you back in my courtroom over and over and over again? Because we started one judge, one defendant down in Las Vegas Justice Court for that very purpose. So that, hey, when I see you, you're not getting credit for time served again. Enough's enough.
Judge Tarmu.
Tell us about JP Edwards, Armed Forces Chamber. Tell us about a legal position you once strongly held that changed after further study or experience. What caused that shift?
I'd say, so some of the more standard cases we handle are car accident cases. And when I also want to say, I'm not a judge yet, okay? I just want to clarify that, okay? Learning evidence after the fact that the accident was staged. If I learn that, that's a very extreme example, but any sort of evidence that conflicts, and it has happened in the past, with my belief in my client that they're telling the truth, then I'll withdraw.
Okay, again, quick, rapid, on your feet thinking. It's been proven statistically that if you keep repeat offenders in jail to the age of 27, that the likelihood of recidivism drops over 60%. Is that something that now you may understand, research, and start taking into account in your sentencing going further, both of you?
If it's an aspect of the law that I'm allowed to consider, then yes.
Yes, and case in point, the guy that got 10 to life, do you know I saw him a few weeks ago at Hope for Prisoners? Because he made parole. And he walked up to me, and and I kind of was like, oh my gosh. And he said, you didn't put me in prison, I put me in prison. And he used a phrase that I won't use because we're on camera, but he said he was a piece of you-know-what. And I was like, no, you're not. Your life has meaning, and you take this going forward, and you mature. And I'm hoping he takes advantage of that Hope for Prisoners program. I hope that he finds meaning in his life and applies himself in a legal way, because ultimately, people do get released. Life in prison is rare and should be rare, and so we as a community need to have the resources available so that people can lead productive lives going forward and not be repeat offenders.
Okay, thank you guys so much. You have 1 minute for a quick closing statement as to why the voters should vote for you. Go.
As I mentioned before, this docket will probably become all civil. Even if it doesn't, though, I have a history of analyzing the law, understanding it in all sorts of areas that I'm not necessarily an expert in, so it translates very well to criminal law. Judge Demonte is an excellent judge. She really is. I have no problems with her at all. However, I think that she should stay in justice court. Okay, she's a fabulous judge, and if she comes to district court, she just doesn't have that experience in civil law that we need. We desperately need. We have fantastic criminal law attorneys as judges now. We need more civil attorneys on the bench.
And I will take that compliment, and I agree. I am a fantastic justice court judge, but I have actually worked my way up, and Department 28 is criminal right now. It is a civil criminal split. There's no such thing as a 100% criminal department. They did away with those years ago. I don't know why. They should bring them back. But I don't believe that shifting calendar things and doing that to members of our community to make them go find their way in a courthouse after braving downtown streets is necessarily something that serves the best interest of the community. Department 28 does handle a criminal docket, and I've worked my way up, and I have proven myself, and I think when lives are on the line, the experience that matters is the experience that has been protecting those lives for 20 years.
Thank you guys for your time today. Thank you for all panel members. That's going to conclude this round of questioning.
Thank you.